SJC-13361, Robert Herrmann and others, v. Attorney General and another.
Okay, Attorney Lessig.
Madam Chief Justice, may it please this court, my name is Lawrence Lessig, and with my co-counsel Ron Fine, we represent two sets of plaintiffs challenging the Attorney General's refusal to certify Petition 2201.
Seems that you're right about the literal language of Article 48, no later than the first Wednesday in August. 2022 is before the 2024 legislative session.
That's right.
And then you go to September, you concede that you got to do the, not the 15 signatures, but 10 signatures, but you've got to be before the Secretary of State in September 2023.
That's
and
right.
then December 2023. It's not a year and a half or whatever.
That's exactly right.
So my question is, why do we decide this constitutional case? Where's the actual controversy? Whatever doctrine you want to apply, ripeness. When we have this situation in the normal course, you get an injunction, and if the signatures get gathered, you get a hearing before the SJC. Why are we pontificating on this without knowing whether it's ever going to be on the ballot?
Well, Your Honor, you should not pontificate, for sure. Instead, you should recognize that in this case, our ability to proceed has been blocked by a ruling of the Attorney General. And the Attorney General is asking you to adopt a rule that would essentially assure that every time a petition is denied, there's in effect $1 million filing fee in order to bring a challenge to her petition. As petitioners alleged, and as was not challenged, the costs beyond the ordinary costs of gathering signatures for a petition would be $1 million just to have the ability to challenge her ruling. Now, this idea is based on a fundamental mistake in her argument. She says the court is obligated to impose an additional textual requirement because the contemplation of the text and context was that the elections were annual, and therefore to enter an initiative.
I understand the Article 74 amendment, it takes care of that argument. That argument goes nowhere.
Great. So then the question is
but
from...
Lockhart also counsels us not to decide constitutional questions unnecessarily. And if every 10-person petition, you file, every 10-person gets together, they decide they want to challenge some very interesting constitutional issue, or a silly one, because we get lots of silly ones too. Doesn't the AG do the initial screening of that by Constitution? And they've screened it out, and you know, you're inviting this court into, again, every time 10 people have a disagreement about a constitutional issue, we may be brought into it. I mean, we can just wait and see if you actually do have the votes, if you do get the signatures, can't we?
Your Honor, the question is, from where does the power to obligate petitioners to gather these signatures derive from? It doesn't derive from Article 48.
You have the right to gather the signatures, and they're going to give you an injunction to do so.
Right, Your Honor. They would give us an injunction, but to force us to gather the signatures in the even-numbered year is, in effect, to force us to adopt $1 million filing fee in order to...
Why is that the case? If you get to choose, Justice Lowy agrees with you that you can file it a year before, and they're wrong on that. You get to choose when you do it, but we don't like to decide constitutional questions prematurely, so we want you to get the signatures. You can get them whenever you want, and the AG does the initial screening. They found it violates the Constitution, and we can leave it there until you get enough signatures to make this a real issue for us.
But, Your Honor, where does the power to say we have to get the signatures come from? When this court decided Horton versus Attorney
You have to
General.
get the signatures to change the law eventually.
That's right. But we have to get the signatures in order to move the petition from the Attorney General's office to the general court. There is nothing in Article 48 that says we have to get the signatures to challenge the Attorney General's determination. And that's what's at issue here.
But it lines up, Article 48 gives you the line when you can file with the Secretary of State. It's not any September and any December. It's no earlier than the first Wednesday of September before the assembling of the general court into which they are to be introduced. Into which they are to be introduced is 2024.
Yes.
So it contemplates that that's where the signature is going to be in that period of time.
Absolutely. But the question is, when are we allowed to challenge the Attorney General's erroneous determination?
When there's going to be a real case with signatures that you're going to get on the ballot, either through an injunction or because you got them.
But, Your Honor, there is a real case when she denies our ability to gather signatures. Article 48 forbids the gathering of signatures without the showing, as this court's decision in Lockhart demonstrates, of irreparable harm from the failure to gather signatures. Her position was that we had to gather signatures last fall. And in gathering signatures last fall, we would have to get an injunction to evade the plain language of Article 48 that says that you can't gather
You
signatures.
don't have to get the signatures last fall. I know they said that. You can get the signatures in September through December of 23. That's not right. You don't have to get the signatures
Okay, great.
last fall.
Then the question is, do we have to gather signatures under the cloud of this being a non-certified petition? Because that was her judgment, that it is not consistent with the Constitution. And that's not hypothetical. That judgment says that the ability of us to gather volunteers or to gather people behind a movement has been disrupted by an erroneous constitutional judgment.
Well, maybe, or it's a correct one. But we don't, you're bringing us into this fight very early and requiring us to decide constitutional questions prematurely. Now, we may have improvidently agreed to hear this at this time. That may be an issue for us.
But, Your Honor, Horton versus Attorney General creates the obligation that this court will review the Attorney General's determination. Horton didn't say anything about waiting until signatures were gathered, didn't force on us an obligation to bear the $1 million filing fee in order to have you make that determination. That determination is ripe when she makes an erroneous constitutional judgment. And the constitutional judgment is the plain application of Article 48. It's whether, under the standards of associated industries, it is certain that this is violating of...
I see you have a very short period of time, so you're splitting your time, or I can't remember. But I just want to make sure we don't lose you on the constitutional issue.
Please.
Given, I assume you're the Lessig who writes about all this stuff, so I hesitate to disagree with you, but I find no support in, it seems to me the AG's clearly right that, you know, Citizens United created this sort of impenetrable First Amendment armor around expenditures. Is there anything, and it keeps making the point repeatedly, I glanced at it again this morning, that this is not a contribution. So where in Citizens United is support for this? Can you point me, because I hesitate to disagree with you, but I can't find it anywhere in there.
Citizens United addresses limitations on expenditures. And the whole case
But the
here...
whole thing is saying that expenditures are different than contributions.
Yes.
And that we're not going to find quid pro quo in the expenditure world. We're going to limit that quid pro quo to the contribution world.
Right. So as I would outline the argument that we intend to make, my colleague Ron Fine will address the quid pro quo argument. Mm-hmm. And what I will address is the argument that it's improper for the Attorney General to restrict our having a petition on the basis of a prediction about what the Supreme Court or this court...
That's not what they're doing. That speechnow.org or what we said in dicta in A1 Auto, they're not predicting what the Supreme Court's going to do. They're rolling up their sleeves and doing their job and deciding whether what's been said out there about independent expenditures is violative or not violative of free speech, which is their obligation under Article 48.
And I would agree if they were speaking about expenditures, but we are talking about contributions. This provision would limit contributions to independent expenditure PACs.
Did you look at what Chapter 55, Section 1 defined a contribution as, by any chance? In case you didn't, a contribution of money or anything of value to an individual candidate, political committee or person acting on behalf of said individual candidate or political committee. Putting aside that in A1 Auto we said that we confirm that making unlimited independent expenditures as well as unlimited contributions to independent expenditure PACs constitutes significant form of political expression. Putting that dicta aside, that's how we defined contribution.
But, Your Honor, that dicta is at the center of the Attorney General's own letter. When she denied certification, she wrote, Massachusetts courts have not specifically weighed in on the constitutionality of laws limiting campaign contributions to independent expenditure PACs. She could have added, neither has the United States Supreme Court. And those two statements together should have resolved this case.
But that's, I mean, the Supreme Court decision is extremely, I mean, they go on and on about saying, I mean, every expenditure has to have a contribution in it, right? You don't have money to expend unless someone gave you money. So
That's
you're
right.
essentially going to gut the whole meaning of the expenditure thing if you look at,
Your Honor, if we were before you with a petition that said we wanted to limit independent expenditures, this would be an easy case. But as this court recognized in 1A Auto, the court made a fundamental distinction between expenditures and contributions. And the question that we are teeing up, as has been teed up in other contexts, is whether contributions shall follow the same rule as the expenditure.
but
Well, it's more complicated, right? It's contributions to the super PAC.
That's right.
Right.
It's contributions to independent expenditure.
Every federal court that has looked at the issue has said that's unconstitutional.
That's right. And, Your Honor, here's the one contribution I hope you will allow me to make in the argument today. Every single federal court to consider this matter has concluded that, in fact, this is restricted by Citizens United. But in none of those lower federal court cases did the court apply a principle of originalism, not one. And the single most important fact about the United States Supreme Court over the past decade is that over the past decade, originalism has become the dominant mode of interpreting the Constitution. It has given us an individual right to bear arms, reversed the right to enroll. And so the Baxter plaintiffs ask why that same principle doesn't apply in the context of campaign finance rules.
Isn't that predicting, like you're saying the AG engaged in?
Well, Your Honor, we've said the AG has predicted that when this question gets to the Supreme Court will conclude the same as it did in Citizens United. That is a prediction. We're giving you a reason to doubt that prediction. And in particular, this is the part I hope you will allow me to contribute, because it's clear originalism would allow would allow the regulation of that this petition advances. It would allow regulations for corruption beyond quid pro quo corruption. It would allow the kind of regulation that Chief Justice Budd was talking about in her concurrence in 1A Auto, where she described the substitutes and agents principle. It would allow it. And we don't offer these arguments to say that this court must follow originalism or even to predict that the Supreme Court will follow originalism. This is what we argue. When it is true that principles articulated by justices on the United States Supreme Court, if applied consistently, would not block a petition, at the very least, that should constitute a genuine dispute requiring the Attorney General to allow the petition to go forward. Put differently, she should not block a petition based on the prediction that justices on the United States Supreme Court will not act in a principled way. If these are their principles, then in the language of Associated Industries, it is certainly conceivable, quote unquote, that they would follow their principles or to permit plaintiffs' petition to stand. Or to put it the other way, it is not inconceivable, is it, that justices on the Supreme Court will apply their principles consistently. And if they do, then there would be no basis for finding this unconstitutional. And in the standard of Associated Industries, which asks this court not to weigh the First Amendment standards and to make an ultimate First Amendment judgment, but instead to ask whether it's conceivable that this petition is constitutional so that the people have a right to vote on it. There could be no doubt that under that standard, this petition should be allowed to proceed.
I hope you are right that it's not an unreasonable belief.
Your Honor, I have personal experience.
I know.
Clerking for Justice Scalia, I can tell you, they can behave consistently, whether we perceive it or not. And if they did, then the type of corruption that, again, Chief Justice Budd has described could begin to be within the scope of what legislatures or the people could regulate. And that opportunity to at least give them the chance to say whether they're going to be principled or not can only occur if courts like this court begin to recognize the actual gaps in the actual opinions, because the court has not, the Supreme Court has not addressed the question of limitations on contributions to independent expenditure PACs, even if it has addressed limitations on expenditures. I'd like to allow my colleague to address now the question of quid pro quo corruption.
Thank you. Okay, Attorney Fine.
Thank you, Madam Chief Justice. May it please the court, Ronald Fine for the Herrmann plaintiffs. Because the Herrmann plaintiffs agree with Professor Lesser regarding mootness, I'd like to focus my time on two issues: the standard of review and the quid pro quo corruption interest that this petition serves. The standard of review in this case is obvious impropriety. As stated in the Yankee Atomic Electric case, Associated Industries rephrase that as whether it is reasonably clear that it violates the freedom of speech, or in this case, any excluded matter. Unless it is reasonably clear, then neither the AG nor this court should prevent the proposal from moving forward. That's intended to be a threshold screening. Here, the single justice acknowledged that there were novel legal arguments presented on both sides. This is not clear. This is much more like in Associated Industries, where the court said, we regard ourselves as fortunate that we need not attempt to resolve the uncertainty of the constitutionality of the proposed law under the First Amendment. Here, what we have is an issue that has never been decided by any court with jurisdiction over Massachusetts. Not this court, not the U.S. Supreme Court, not a superior court in Massachusetts.
Go ahead.
You know the dicta in A1 Auto, though, right? Where we said that Citizens United permitted corporations to engage in significant forms of political expression that was not allowed in Beaumont when Beaumont was decided. That is, to make unlimited independent expenditures as well as unlimited contributions to independent expenditure PACs.
Your Honor, that dictum is in 1A Auto, but it is in fact dictum because it was not the issue presented there, and it is an issue presented here. So now that we've got it squarely on the table, we can acknowledge that, yes, there are lower federal court cases in other parts of the country, 7th Circuit, 9th Circuit, 2nd Circuit,
Well,
that
it's
have
not
ruled
just
that
the
way.
lower federal courts. I mean, I've got Citizens United in front of me. Tell me where, I'm just reading, I can pick out 10 of these. The absence of prearrangement and coordination of an expenditure with the candidate or his agent not only undermines the value of the expenditure to the candidate, but also alleviates the danger that expenditures will be given as a quid pro quo. There's tons of statements in Citizens United. Whether you like Citizens United or not, there are tons of statements that say expenditures are not quid pro quo issues. It may be silly reasoning, but it's the reasoning. So I don't understand how you're getting around it by saying the contribution to the PAC is in a different category, because you can't have expenditures without contributions. They're not the same as contributions to the candidate. They're different. Go ahead.
Thank you, Your
And
Honor.
also, tell me in Citizens United what I can rely on, because I've just got the text here.
Sure. I would say Citizens United and McCutcheon, which came after it, which explicitly upheld the authority to regulate contributions in the interest of preventing quid pro quo corruption.
Contributions to independent PACs, super PACs?
Your Honor, if I could walk you through a concrete example of how this would actually play out. Let's take as given that Citizens United has held that independent expenditures themselves cannot be part of a quid pro quo transaction. So here's the situation. So he is a donor. He wants to make a big spend in favor of a candidate. I'm sorry for doing this, but you are now a politician, and you are running for office, okay? And I am the person who's running a super PAC, okay? Now, I am an expert in scripting TV ads, buying media time, bidding on radio slots, Facebook search terms, okay? I'm not gonna talk to the candidate. I'm gonna spend $1 million to support her. I'm not gonna talk to her at all, because that would be coordinating, and then my expenditures would count as coordinated expenditures, which are contributions. So there's no quid pro quo happening between me and her. He is running a widget factory, and he wants her to vote yes on the widgets bill. So he is gonna talk to her without me even involved, and he's gonna say, I'm gonna make $1 million contribution to the super PAC that supports your reelection if you agree to vote yes on the widgets bill. She can say yes to that. That's quid pro quo bribery. The super PAC is actually not even involved. It doesn't need to be. That actually happened in an actual federal bribery case that we cited in our briefs, the Menendez case, where the briber bribed the politician, allegedly, without any involvement by the independent expenditure PAC. So the independent expenditures are not corrupting, but the conversation between the donor and the politician can be part of quid pro quo corruption. Now, under the Speech Now line of cases, which all arose immediately after Citizens United, 2010, 11, 12, super PACs didn't even exist at that time.
By the way, your petition isn't directed at that. It's directed at just any expenditure over $5,000 from him to you, right? Or is there this express bribery component to this, or is it?
Your Honor,
it's any $5,000, anything over $5,000 is banned, right?
All contributions are prophylactic. Contribution limits are prophylactic, and that's the basis on which the Supreme Court has upheld them. Just like you could make, in theory, you could write
So isn't it clearly overbroad? I mean, you're worried about this one thing where they're secretly telling you, I'm going to give so-and-so to avoid this, but that's not what your bill says. Your bill is directed at every contribution over $5,000,
Well,
right?
just like the contribution limits to candidates are limited at $1,000. No one is saying that all contributions of $1,001 to a candidate would be bribes, but the contribution limits are authorized at $1,000 because they prevent quid pro quo corruption, or just as importantly, its appearance. And so that's the basis for regulating contribution limits under 1A.
Say there was a carve-out for just what you're talking about. Wouldn't that make your whole petition overbroad and sweeping in all kinds of protected speech under Citizens United? So even if we did recognize your little hypothetical here, which is of some concern, you're preventing any kind of contribution to the PAC, which seems to fall right in smack into what Citizens United doesn't like, right?
Your Honor, it's the exact same analogy as contribution limits to candidates. A $1,001 contribution to a candidate in Massachusetts is illegal, even though most of them wouldn't be bribes. And that's because the contribution limit is defensible on the basis that it helps prevent quid pro quo corruption. Now, here we have a case where under current law, you can make a $10 million contribution to a super PAC supporting a candidate. And without this law, the case law that the Attorney General is relying on says that has no possible corrupting value. And that doesn't withstand scrutiny. It's not logical, and it's contradicted by both the actual bribery cases that we've cited in our brief and the appearance of quid pro quo corruption that the public perceives documented in surveys.
And that's why Citizens United has been condemned so intensely, but it doesn't mean we get to revisit that.
Your Honor, this petition does not contradict Citizens United as properly interpreted, which says that the expenditures may not be corrupting, but contributions can be, because the contributor can talk to the politician even if the expender can't.
Any case law in the country at all that we can look at where a contribution to one of these PACs is treated like a contribution to a political candidate as opposed to being part of the expenditure analysis under, but any case, I know there are 30 going the other way. Just give us one case that we can look at to help support us.
Something very close to that, Your Honor, which is in Republican National Committee versus Louisiana, which is one of the cases cited in our briefs.
It's in the brief?
It's cited in our briefs. It's a Republican Party of Louisiana versus FEC. It's a DC Circuit or three-judge court case that was summarily affirmed by the Supreme Court. It's very close to your scenario. It involves the soft money limits in federal law, which say that in certain cases, political parties can spend money independently, without coordination. That is the question. And the Chief Judge Srinivasan of the DC Circuit said that the inducement comes not from the spending, which is independent. This is a 2017 case, well after Citizens United, but rather from the contribution being made in the first place. Now, again, I don't think that we need to have circuit cases in support of this. Associated Industries didn't cite a single circuit case. Neither did Yankee Atomic Electric. They just looked to Supreme Court case law and this court's own case law. But to the extent that there is a circuit case, that is the most helpful that I could think of right now. So I see that my time is over, but if I may have another minute or two, I'd like to just wrap up, which is that the existence of the potential of quid pro quo corruption through super PACs was theoretically comprehensible in 2010 when Speech Now was decided, but it may not have been as apparent because no one really understood how these would evolve. Those laws challenged in the set of cases from 2010 to 2012, they weren't specifically regulating contributions to independent expenditure PACs. They were pre-2010 laws that were challenged as applied to independent expenditure committees. Nobody had seen what had happened with these. In fact, Attorney General of the United States declined to appeal Speech Now to the US Supreme Court because he said it would affect only a small subset of contributions. We've now seen, to the contrary, that contributions to independent expenditure PACs dwarf direct candidate contributions in many elections. And why not? Because you can make a $10 million contribution instead of a $1,000 contribution. The Boston mayoral election, we saw a $1 million contribution by a single individual when you could only contribute $1,000 directly to a candidate. We now have the experience of over a decade of super PACs that unfortunately came after these decisions. We've seen actual bribery cases coming through donations to super PACs. We've seen public opinion surveys which contribute to the appearance of corruption. And if this initiative is allowed to go to the ballot, I predict we would see an overwhelming public vote in support, which would itself be evidentiary of the appearance of quid pro quo corruption.
I just can't find this site you're talking about. I'm looking at your brief. Which case is it?
Sure. It's Republican Party of Louisiana versus FEC, 137 Supreme Court Reporter 2178. We cited page 45 of our
I thought you
opening
said it was a
brief.
DC, so it's a US Supreme Court case?
It was, I believe, it's either a three-judge court or a
All right, so
or a DC Circuit case that was summarily affirmed.
Okay,
Following
so
McConnell,
we can find the site from the Supreme Court case.
yeah,
Okay,
and
I
it said
gotcha.
that the inducement came from the contribution to the soft, and again, soft money, much like independent expenditure PACs, is not supposed to be coordinated with the candidates. So in conclusion, this is anything but reasonably clear at this stage. Now, this court finding that it is not reasonably clear that it violates Article 16 would allow this court to preserve its options. It would not foreclose this court, if the initiative passes, from revisiting that finding upon a full factual record. And as this court said in Associated Industries, this is only the first opportunity for the constitutionality to be attacked. In conclusion, we ask that this court find that it is not obviously improper, that it is not reasonably clear that this petition violates Article 16, and I thank you.
Okay, thank you. All right, Attorney Sturman.
Good morning, Your Honors, and may it please the Court. My name is Ann Sturman, Assistant Attorney General, appearing today on behalf of the Attorney General and Secretary of Commonwealth, and with me is Assistant Attorney General Adam Hornstein. Your Honor, this Court should decline the petitioner's request for what is essentially an advisory opinion as to whether or not their proposed law addresses a matter excluded from the initiative by Article 48. Their ahistorical justification for their request runs headlong into a number of practical reasons and sound prudential reasons why this court should adhere to its practice of declining to wade into moot constitutional questions.
Yeah, the problem is it's not really moot. I get we shouldn't be messing around with theoretical constitutional issues, and that may be a reason why we shouldn't decide this case, but it meets the language of the constitutional provision. It's done, whatever it is, no earlier, I can't remember the no later. It meets the requirements, and it's a live issue if they actually can get the signatures for it. And we don't usually sort of sit around with, I mean, I understand their point. It's going to be harder to collect the signatures. That, I'm not sure I feel that should compel us into deciding an incredibly novel, difficult constitutional issue that probably will get us smacked down by the U.S. Supreme Court. But can we really do that? If this is before us and we don't agree with you that it has to be filed the year later, do we have to decide the case? Or, I mean, we don't have to do anything, I guess, but what do we do with a case that isn't moot? Because I don't find it moot.
And Lockhart is an odd year case, so that doesn't help.
Lockhart is an odd year case, but it did address also some of the same or similar arguments to what the petitioners here raised. In Lockhart, as in some of the cases in which the single justice has entered the injunction to allow petitioners of a declined petition to gather signatures, an argument was advanced as to the difficulty of gathering signatures on a petition for which the AG has not granted certification. In Lockhart, although it was an odd year, petitioners made the point that they could resubmit the petition again the following year, and none of those reasons did this court find compelling enough to determine that the question was not moot. So,
But Lockhart, going to Justice Kafker's point, I do not see how this is moot. I don't see how Lockhart helps you on mootness. There's a complete recognition in an odd year case that they weren't going to make the December signatures to the Secretary of State. So the issue is not moot. So going back to Justice Kaffer's case, maybe I shouldn't say pontificate, but do we address this issue? Is there an actual controversy to resolve? There's a way to do this, which is to get an injunction and gather the signatures, and if you make them, have it heard by the court.
I think that's right, Your Honor, and the most important point here is the point that this court should not reach the constitutional question in the vacuum in which the petitioners are asking this court to reach it. So
Okay,
in the alternative.
So how do we, okay, I get that, and we want to avoid deciding constitutional issues unnecessarily, particularly difficult ones. But the cases before us, the issue was a live one when we took it. We're probably, you know, if you're wrong on the first point, the case is not moot. It's before us. So how does it read? And assume the following extra step. We disagree with you that it couldn't be filed a year ahead of time. But we do agree we shouldn't be deciding cases unnecessarily, and that, you know, get the signatures. That's, you want to change the law of the Commonwealth, you know, you got to spend money to change it, because you're not the elected officials of the Commonwealth, and we don't let 10 people dictate whether anybody does this. So how do we decide this case? How does that write?
So in that event, I think Your Honors would find that the matter is not ripe for adjudication for this court, because the petitioners have not demonstrated the requisite public support in the form of the gathering of signatures that is required by Article 48.
Where is that in Article 48?
That the petitioners must gather their signatures in order to get review from this court?
Yes,
Candidly, Your Honor, it's not.
right.
Article
That's a problem.
48
So
doesn't address.
what is the basis of this argument entirely? We have a petition that wants to be on the ballot in 2024. We have the AG saying no dice. We have engagement of two opposing views and actual controversy, and nothing in the language of Article 48 that says ye must get an injunction in order to get the signatures. In fact, the whole purpose of the injunction is to get around the Article 48. So they've actually brought this timely. I don't understand why this is not. I get we don't decide constitutional issues unnecessarily, but isn't this a situation where we have a ripe constitutional issue that's not moot?
I don't think it is, Your Honor, because we don't know whether this petition and these petitioners will meet any of the other requirements that they have to meet in order for this to be on the ballot and appear before the voters.
But isn't the order of Article 48 anticipate that they get certification? And the point is you haven't certified it, and so they have an actual controversy in terms of that certification because you have now deemed this to be reasonably clearly unconstitutional?
I guess, Your Honor, this is where we lead into some of the practical concerns. So these
I
petitions.
don't know if you even have to lead into practical. Legally, the court often, initiative petitions are decided in all different stages. Some courts wait until they actually pass the public before they will even review them. This court has been very generous in getting involved very early, but we don't have to, right? There's no legal requirement in the Constitution that the SJC has to weigh in at any particular time in this process. As a practical matter, we've been weighing in when the votes make it a live issue. We don't have to. We could actually wait until after the public decides this issue. A lot of courts do that around the country, right? We're unusually proactive.
You absolutely could.
And
Your
we're
Honor.
about to be under their view, we would be the most proactive by far because we would be jumping into things a year ahead of time when we have no idea whether anyone but 10 people are interested in this, right?
Right, and we have no idea, although these petitioners are telling us that they intend to gather signatures next fall, the next group of petitioners may not. Or they may tell us that they intend to gather signatures and then choose not to. And then we've got this advisory opinion from the SJC on the constitutionality of their proposed measure with petitioners that don't even intend to proceed with the process. I think the practical challenge we're all struggling with is that Article 48, you're right, on its face, does not have a provision with respect to when and how this court should review the certification decisions of the Attorney General. Now, we acknowledge that it is within this court's power to review those decisions. And so then the question becomes, when in the process does it make sense to do so? We have competing concerns.
Does it matter how good the argument is? Because again, any 10 people can propose an initiative petition, whatever they want, right? So do we have to look to the merits, how close a call this is to decide? Is that a standard? Or is it anything goes?
I mean, looking to the merits and how close a call would be an awfully difficult standard, I would think, to implement. I think if you, as a practical matter, look at what would happen to the Article 48 process if the petitioner's suggestion were adopted. Right now, as the court well knows, the vast majority of petitioners choose to file in August of an odd-numbered year. They proceed with signatures, either by form of an injunction.
Although they do create a crisis every year. And to their credit, they're avoiding a crisis, which is, and your workload also will not be crazed as every June for the last, 20 years it's been, right? So there's some value in teeing this up early if it makes some sense.
I think the challenge, Your Honor, is that while it might create less of a fire drill in spring of the even-numbered years, it would result in an incentive system that would result in us having more cases brought in the odd-numbered years.
But would that be a bad thing? Because wouldn't that just mean that the citizens of the Commonwealth are participating more in democracy?
I think it would be a bad thing if it were being used as a means to obtain otherwise improper and improvident advisory opinions from this court.
But why do you call it an advisory opinion? Is it because we don't know in the future whether they will actually go through and get the signatures?
That's right, whether this
So
will
what
actually
bucket do
become
we
law.
put that in? It's not mootness, it's not ripeness. What is it? Just practically we don't want to do this?
I think it is the court's long-held jurisprudence cautioning against issuing opinions where there isn't an active controversy.
Well,
A number of these cases, as single justice, I've issued the injunctions. A number of these cases die on the vine, correct?
That's right.
More do than don't.
In terms of petitions that are not certified, for
keep
which
fighting.
petitioners then try to get signatures, most of them don't succeed in then reaching.
But isn't the whole constitutional provision based on the fact that the initiative process is an exception to the democratic process, and you need to get a lot of citizen support at multiple stages of the process for us to devote a lot of energy to it, right? So I think that's your best argument, that there is textual support for holding off here, because the provision doesn't, it makes it so difficult to, how many signatures do you have to get? It's a certain percentage of the,
Half of 1% of what the governor got?
So for the first round of signatures, the one that occurs between September and December, it's 3% of the votes cast in the
the number
previous.
for that year would be what?
So I don't know what it will be based on the most
Last
recent
year.
gubernatorial election, but the last time I believe it was 80,289.
It's a lot different to have 80,209 people interested in something than 10.
I agree with you.
One might be able to do the math.
Can you talk a little bit about since you did brief it, the decision not to certify?
About the merits of the decision not to certify that. So, Your Honor, I think for better or worse, the Attorney General's role here is that of a gatekeeping role. She must assess the law as it exists and the facts as she can reasonably notice them at the time at which the proposed law is submitted to her for review. And as the plaintiffs here acknowledge, we've got the Citizens United decision, and we have a chorus of federal appellate courts who have uniformly held that an inexorable conclusion from Citizens United is that the contribution limits proposed by this law violate the Constitution. Now, they may disagree with the reasoning of those cases. They may predict that the current Supreme Court would determine differently if presented with the issue, but the Attorney General's role in this procedure is not to predict, is not to make certification decisions based on the law as she wishes it would be, or on her policy preferences, but to call the balls and strikes based on the law as it is. And it can hardly be said to not be reasonably clear that this infringes upon an excluded matter, where the courts who have addressed this matter have spoken so unanimously.
Well, but your opposing counsel articulates some reasons that's not quite accurate, or in his arguments that's not quite accurate, that in fact there are differences between what he's asking in this petition and what those cases have held. How do you address his argument there?
I think to the extent there are any differences, he has not explained, I don't think, why the reasoning that those cases employed would not be equally applicable to the law that's proposed here, nor can he point us to a court case that indicates that the proposed law, as formulated by these plaintiffs, would not fall within the reasoning of
Do you
all
need
those
a
cases.
court case for us to determine whether something's unreasonably likely to, I forget what the language is, but.
I don't think the Attorney General needs a court case precisely on all fours with the petition. She is charged with exercising her discretion to determine whether or not the proposed law infringes upon an excluded matter. It is true that this court has not addressed the precise legal issue that the plaintiffs are raising. It is true that there is an argument that perhaps Citizens United might come out differently if framed in this particular lens and put before this particular Supreme Court. But I think asking the Attorney General to base her certification decisions on that would be going far beyond what Article 48 contemplates the Attorney General's role to be, which is to look at the law as it exists, to look at the facts that she can reasonably notice in the limited time and context provided by Article 48, and to assert in her discretion whether or not the matter infringes upon an excluded matter, and I think the Attorney General reasonably did so here.
Are you able to address that Republican Party of Louisiana case at all?
In what
Counsel's
context?
soft money case?
Yeah, the soft money case.
I'm not, Your Honor.
Okay, thank you.
I don't think that case
We,
changes the conclusion in light of the chorus of other cases speaking to the
in one of our cases, I can't remember, I think by the late Chief Justice, he put time deadlines onto when things should happen, which of course have been ignored since we did that. If we don't adopt your view, should we be imposing such time things, saying you should wait until the next year? Is that your sense of what we should be doing, similar to what Chief Justice Gantz did in that opinion?
I think Your Honor may be referring to the Dunn case.
Yes.
And I think the challenge here is where Article 48 prescribes such tight timelines and doesn't actually address the issue of judicial review, the challenge is figuring out where to plug that into the process when we are sufficiently certain that a matter may reach the ballot without having to wait until the voters vote, because I think we all acknowledge that that's suboptimal as well, to ask the voters to vote on something. I don't know that prescribing a strict schedule necessarily makes sense, but I think that the reasoning makes sense, which is that we need to be balancing when the matter is appropriately ripe versus waiting until the voters have been prejudiced by being asked to vote on a measure that the court will ultimately then throw out. If there are no further questions, I'd urge this court to uphold the Attorney General's certification in the event that you do not find that the question presented is moot. Thank you.